Welcome to the DNS podcast, Mr. Shaunak Sayta.
Good morning and thank you for having me.
It's an absolute pleasure at the DNS podcast. Why did you choose law as a profession?
Well, I chose law as a profession because I was really interested in law, and it's one of the few options that you have after graduation from an intellectual standpoint. In India, after you graduate, typically you've either done your BCom or your science or whichever background you've come from. You don't have a ton of other options other than doing an MBA or a chartered accountancy course, which you could take up as an alternative. So law is one of the really intellectual pursuits which is available after graduation, and that's an attractive option. So that's why I chose to do law.
Interesting. What aspect of being a lawyer interests you the most?
The adversarial aspect, where you have to advocate for your client. So at any point of time in law, right, there's sort of two aspects to it. Either you're making contracts and you're sitting in the office 24 hours a day and you're doing compliance work for some government department, or you're going to court and you're fighting in court for your client. So what really interests me is the adversarial aspect of law, where most people would shy away from disputes. They don't want to really get into an argument or get into a fight or sort of try to resolve a situation where there is conflict. And that is really what interests me the most, because I don't get affected with conflict. I am sort of naturally wired to deal with conflict in a positive way, to try to get a positive outcome for everyone associated in that conflict. So that's why, that's what really interests me, and that's why I took up law, and that's why I like to do conflict resolution in what I do.
Right. So when you talk about fighting for your client, arbitrary law, when you're talking about this, what is that one particular aspect which is really you're passionate about?
So getting the best outcome and fighting to, our sort of ethical codes talk about zealous advocacy. And, there have been certain instances where clients' conduct has been such that no lawyer would like to have that kind of a client. Right? Where, for example, say someone is a child molester or a murderer or something of that sort. So if you open textbooks of law, right, you'll read about such examples where lawyers have defended even such people, and the lawyers have been sometimes sent to jail. In some countries, where lawyers have been told, look, if you do this or if you continue to defend your client in this manner, then we will put you in jail. And there have been instances where lawyers have gone to jail just to defend their client as a matter of advocacy for your client. So it's a very inspirational way in which you have to approach that, and you have to sort of be there for your client because he's expecting the best from you.
True.
So zealous advocacy is extremely important as a lawyer. And zealously advocating for your client, being the mouthpiece for someone who's not able to understand the situation that he is in and who's not able to correctly put out what he has to say.
Right.
So that is exactly what advocacy is all about, where you advocate for someone, and that advocacy does not end in the courtroom. It continues even outside of the courtroom, right? And you have to continue to push and push and push for your client. That is what advocacy and dispute resolution is all about, because disputes arise all the time.
True.
And everywhere you look, you're going to find conflict and disputes. It may be a small thing, it may not result in a litigation, or it may not result in something that goes to court, but resolving disputes in a effective and cost-effective, I would say, in a cost-effective and very efficient manner without wasting resources is exactly what advocacy and arbitration is all about.
Right. Interesting. I did not know about that fact, and thank you so much for sharing it with our audience. What are the challenges you face as a lawyer?
Challenges are in terms of time and in terms of availability of resources to deal with a particular kind of situation, right? So whenever you have a conflict, right? You have not just the legal or the sort of textbook way of resolving that conflict, but you can have out of the box situations where you can have a protest, for example, right? Like if you look at the current protests that are going on for the farmers in Delhi, or
Right.
or the sports people who are affected by certain whatever was done by that minister, right?
Right.
So
The wrestlers, you mean?
exactly. So they did not get justice, right? They did not get justice at the outset,
Absolutely.
but they had to go there and they had to protest. But what happened as a result of the protest was that they were heard and they did receive some sort of fair outcome, I would say, in terms of the fact that the investigation is going on, right? So at least the investigation took place, something happened, right? It moved forward, right? That would not have happened had they just sat down and said, okay, we have, this has happened to us and we have sit at home and just vent out your frustration on your family members. That's just that's not going to happen. So you need to do something. You need to act in order to resolve a conflict.
True.
Right? When there is a conflict, managing that conflict, getting a good outcome in a cost-effective manner, that is exactly what arbitration is all about.
Interesting. Yes, that's something which I really never knew about. And thank you for putting the insights on that topic. If you would like to go back and fix a mistake you made as a lawyer, what would it be and why?
Niraalee, I think that fixing a mistake that has already been committed is sort of like an act which is really useless.
Right.
What is really important about mistakes is to learn from them.
True.
And to improve yourself so you don't make those mistakes again.
Right.
But obviously I've made many mistakes in my life and everyone makes mistakes. That's an essential quality of what makes us human.
True.
So definitely, as a lawyer, as you're sort of growing and you get experience, you would have definitely made many mistakes in many cases, and those small mistakes may or may not have led to any significant sort of changes in outcome in relation to the clients. But you would like to strive to minimize those mistakes as you go forward. You collaborate with other lawyers, you ask people questions if you don't understand something, and there's no shame in that. No single lawyer can possibly know everything that there is to know about the law. Like that's why we have books where we read them, and we have Westlaw and Lexis and several resources. Like in India you have Manu Patra. You have several resources to read and get knowledge about something that you don't understand, and you improve yourself and you try not to make that mistake again, and hopefully the judge doesn't catch on to that, right? And if the judge does catch on to that, then the best thing to do is to apologize and say, I'm sorry, this is my mistake and I'm not going to do that again, and apologize to your client and try your best to make the situation whole.
Interesting. Yes. You specialize in arbitration law. Can you share your micro niche on this segment of law with our audience?
Sure. So, arbitration law is basically dispute resolution outside court. Like, traditionally, so to speak, you have several types of disputes. You have criminal disputes, you have marriage, you have, income tax disputes, you have sales tax disputes, GST disputes. You have disputes in several different tribunals across the country. But the quickest and the fastest way to resolve a dispute is through arbitration.
Right.
And what arbitration means is basically having a court outside court. So you appoint someone called an arbitrator who acts as a judge, and he resolves your case as if you are in court. Right. And the resolution that the arbitrator provides would be binding, as if it is a judgment from a court. So then you can use the court system after you have engaged in arbitration to enforce the award of the arbitrator.
Right.
Like suppose, for example, if the arbitrator says that, someone has to pay you X amount of rupees, then you can go to court and attach that person's property to recover X amount of rupees. So you can use the infrastructure of the court to enforce arbitral awards. So the arbitrator gives you something which is called an award, and that is his decision. It's like a judgment from a court.
Right.
And that would be enforceable through the courts. So that's very efficient because, like, just to give you an example, in any day, in any court in India, you would have more than one case. Right? Like if you stand outside the court, you will see that there are probably 50 or 100 or 200 cases that are listed. And one case comes up, then the judge goes to the next one, the third one, the fourth one, so on.
Right, the flow just continues.
It just goes throughout the day. There would be like maybe 100, 200 cases that one judge has dealt with. But as far as arbitration is concerned, right, you're the only person that there is.
Right.
So the judge or the arbitrator, he gets your full attention, right? And you get his full attention. So it's a more consultative, detailed sort of approach where the technical rules of evidence and the rules of civil procedure don't apply.
Right.
So you have a very sort of informal way in which a particular dispute is heard by someone who you select as a judge. Right. So that's another feature of arbitration where, when you go to court, you don't get to decide who the judge would be. But if you go for arbitration, you get to decide, right? Before you have a dispute, you get to decide that, look, if I have a dispute with you, this guy is going to be the judge and he's going to decide who's right. And then if he decides that someone is right, that would be enforced by the court. It would be recognized legally to be able to get your money back, right? So that's the biggest advantage.
Right. Who appoints the arbitrators?
So there's two options, right? Or three options actually. Either the parties appoint the arbitrator
directly.
Yes. So, you would have a typical situation would be you'd have a contract before you do a particular business deal or an investment or whatever you are doing in business with that person.
Right.
And that contract will say that this contract is subject to arbitration.
Okay.
Right. You just need one simple line in there which says this contract is subject to arbitration. And after that, everything follows from there. So if you want to name the arbitrator in the contract itself, you can do that. So you can say this contract is subject to arbitration. All disputes shall be resolved by Mr. A, B, C or Mr. XYZ as the arbitrator. Right.
Okay.
So if that is the case, then you have to go to that person when there is a dispute. And you selected him before when you signed the contract. So he will decide the dispute. And then if the other party refuses to comply with that, then you can go for enforcement proceedings or attachment and so on.
Right. How does arbitration happen in India?
So in India, there's many different types of arbitration. The first type I would say would be arbitration which happens between two Indians.
Right.
Right, where you have one Indian who's a plaintiff and one Indian who's a defendant.
Okay.
That is typically called domestic arbitration. Right. But if you have one party who's a foreigner and one party who's an Indian, then that would be called international arbitration.
Okay.
So either you have domestic arbitration or you have international arbitration. The rules for domestic arbitration and international arbitration are very different.
Right.
Right. So as far as domestic arbitration is concerned, it happens pretty much all the time in India. Right. Like you have typical scenarios where you have domestic arbitration would be in government contracts, right, where you have these infrastructure contracts. Like, for example, there was a major arbitration award that recently one of Anil Ambani's companies won against a roadway project. So, you have several sort of domestic contracts, right? For example, pretty much any contract that relates to purchase and sale of securities on a stock exchange is subjected to arbitration, right? So if you're dealing with a stockbroker, then you can't really go to court for that. You have to go for arbitration. And many other contracts which are sort of standard form contracts, like for example, when you purchase a domain name, right? If someone says that I have an intellectual property in that domain name, that dispute would be subjected to arbitration. So, you can definitely, even when there is arbitration, you can go to the court for interim relief, which is sort of basically like saying that, you're telling the court that till the time that this arbitration is going on, I need a certain amount of relief, which would make my dispute really useless if I don't get that relief. So give me that relief till the time the arbitration, subject to the outcome of the arbitration. So you can do that, right? But mainly the arbitrator gets to decide the dispute that is in question.
Interesting. Even this is very, very interesting for the audience because there's so much happening in Bombay, so many disputes happening in Bombay, and I'm sure that this knowledge is going to be helpful for every Indian. There has been a lot of freedom-related issues and queries on the same-sex marriage in India post the pandemic. What is the current situation of the same-sex marriage in India?
So currently the issue is pending before the Supreme Court, and the whole country is really watching with bated breath what the Supreme Court is going to decide.
Right.
Several arguments have been put forth before the Supreme Court, and the question really that arises in the case of same-sex marriage is who decides? Who decides whether same-sex marriage should be legal or it should not be legal, right? The government of India has argued before the Supreme Court that it should not be the Supreme Court who decides whether same-sex marriage would be legal or not. It should be the people of India who should decide,
right,
and express their opinion through their ballot papers, and consequently elect members of parliament who would have that view, and then the members of parliament would introduce a bill in parliament to legalize same-sex marriage.
Okay.
That should be the route that should be followed in order to legalize same-sex marriage.
Right.
That is what the government is contending in the Supreme Court right now. But what the other side is contending, the people who want legalization of same-sex marriage, basically they're of the view that, you know, the government is never going to follow through and legalize same-sex marriage even if the people vote for it, or they have a view that the rights of people are superior to what other people would say. Well, that's a sort of controversial view.
Right.
It kind of assumes that people don't know what they want, or people would not be able to articulate what they want.
Right.
So this is it's a global sort of issue where many other countries have taken different routes to legalize same-sex marriage.
Right.
But what really works for India is the question. So as far as India is concerned, I feel that the route that should be followed should be one of asking the people what they want and putting the question to the people on the ballot box. Right. And let the people decide whether same-sex marriage should be legal,
right,
or whether same-sex marriage should not be legal. That, again, you know, this is a very sort of narrow question, because the Supreme Court has already held that live-in relationships and so on, right, are subject to the same rules as far as domestic violence and criminal matters arising from those relationships arise. Like, you know, if a same-sex couple is residing together but they're not married technically,
right,
and there's a question of harassment or, you know, domestic violence, then, you know, obviously that person has a remedy.
True.
And that's what the Supreme Court has said. But that doesn't equate to recognizing the same-sex union as a marriage, because there are several other benefits that are attached to being married, and that question is currently the one which remains before the Supreme Court right now, and this is before a constitutional bench, so it's a relatively important and a very sort of live issue, I would say.
Right. When do you think that the government is going to take a decision on this matter?
So it should be coming out soon. I feel maybe in a couple of months, because the matter has already been argued before the Supreme Court.
True.
And maybe I would say it should be anytime soon that the Supreme Court would pronounce whether the Supreme Court is going to agree with the government or the Supreme Court is going to itself recognize same-sex marriage. The Supreme Court obviously has the authority to do that, right, and the Supreme Court may do that if the court feels that it's a question of human rights or fundamental rights that's involved.
True.
You know, in particular Article 21, right to life. So maybe the Supreme Court recognizes it, maybe it doesn't. We don't know yet. If it does, sure, good, that's great. But, you know, it should be ideally going through Parliament.
Amazing. It's insightful again. Have you ever worked on a case that was hard to take back home, and how did you handle the situation?
Well, there have been many cases that I have worked on which were hard to take back home initially, and you have to sort of separate your professional and your personal life.
True.
And you just cannot let it seep into one and the other. Right. You cannot be a more vindictive son or husband or boyfriend, rather, just because you do disputes every day. And you should not let your disputes seep into your personal life either.
Right.
So it's very important to keep both separate, right? Like initially, before I was doing purely arbitration work, I used to do a small amount of other disputes as well. And definitely there was one case where there was custody of a child that was involved, which really sort of hit home for me in that sense. But after that, I've sort of moved on to purely commercial disputes and disputes between businesses purely that relate to who owes how much money to which person.
Right.
And that's just like basically comes down to how much money is involved and who wins that and who doesn't win it. So that's an easier sort of job, I would say, rather than doing the more emotional cases which are like family law related or criminal law related. And I try to avoid that now.
Yeah, makes sense. What has been your work-life balance as a lawyer?
Well, as a lawyer, I don't know if it would be very good for me to say that, but I work pretty much 24/7, right? Because all my clients require immediate attention, right? Whenever there's a dispute, your thinking is such that you want someone to help you right now. Right, you need someone to be there for you at that moment, right, and you need immediate attention, right. So keeping the client happy and getting the best outcome for my client is always what I want. So I try to be there for my client as and when I can, and which really pretty much means that you have to be available 24/7.
That's the one reason I call you very highly skilled and outstanding lawyer.
Thank you.
Tell me about the greatest triumph of your career so far and how you made it happen.
So I have had several cases where money was owed outside of India, and there are some countries where it's very difficult to recover money. Like, for example, African countries or Eastern countries like, for example, Thailand and, to name South Africa and, some countries like Vietnam. So those countries are very difficult to do business with, right? Like, just put yourself in the shoes of an exporter or an importer dealing with those countries, right? Like, if you have supplied goods to them and they don't pay you, what are you going to do? How are you going to get your money out? So those sorts of cases where I have done arbitration and I have delivered positive results for my client, those are the types of cases which were really, really difficult to get outcomes in. And that's where I would say that I have excelled in getting, and my record speaks for itself.
True.
So, like, people call me up and they say, okay, so-and-so told me that you've done a great job in this case, so would you do this for me as well and all. So that's your validation of the work that you do, and that proves that what you're doing is good.
Right. So word of mouth has really worked for you.
Absolutely.
Amazing. What are your thoughts on how AI will change law in general?
That's a great question. And recently in the US, there was one lawyer who used AI to draft his entire submissions in court.
ChatGPT.
Yes.
Fascinating.
So he just put into ChatGPT, give me an entire brief for this particular subject, and he submitted that brief in court without making any changes. And he got caught. He was caught because everything that was in that brief,
right,
it was not cited. So he was citing. So like when you write a brief, you have to say, in this case, this happened. Accordingly,
details follow.
Exactly.
Right.
So in this case, this happened, and accordingly, this should happen in my case.
Right.
Right. So the cases that he had cited were all non-existent. They were all like non-existent cases which didn't really exist. So he got pulled up as a lawyer. The judge said, what is this? You can't do this. You can't file a submission with non-existent cases. And he's actually now facing ethical charges. He might lose his license for using ChatGPT to make submissions in court. But that just shows us, that just shows that ChatGPT is a tool which lawyers are already using
True.
to make their submissions.
But editing is required somewhere.
Some lawyers go overboard in trying to use ChatGPT, missing the point that it's just a tool which has to be used rather than just offer the finished product.
True.
But surely you can use ChatGPT to definitely simplify tasks. And I know several lawyers who use the premium version to get the fastest sort of output when they're sitting in court to be able to give on the spot responses. Sure, you can use ChatGPT and it's a very great tool, and it is definitely going to make some interns and lower level associates jobless, but definitely it has to be tempered with your experience and your knowledge about law. You can't just copy paste. That's the point.
Absolutely, I completely agree with you, because ChatGPT has taken up a lot of content writers' jobs, but what content writers can do, ChatGPT cannot do.
Exactly.
Yeah. Making India the hub of arbitration law, bridging the gap between myth and reality. Your take, Mr. Sayta.
So India is a great place for arbitration, but as far as India is concerned, arbitration is still in the nascent stages. It's not very mature, and that's going to take some time because as a country, as the courts are in India, we always say, look, we are pro arbitration. We want arbitration to work. We want to sort of have more arbitration that's happening in India. But when you go for enforcement, it becomes very difficult. And enforcement is still not happening very well. So, it's very great to say that we want to have India as a hub in arbitration, but look at the enforcement record.
Right.
Like, the enforcement record isn't that great in India. So you can have great arbitration, but when you are not going to enforce arbitration, that really affects your own record as a country.
True.
Right? And the prime example of that in India is the government itself. Like, there have been so many arbitrations that have taken place where the government is a party, right? Like, there are disputes in relation to contractors of governments and international contracts that the government has entered into,
right,
but the government refuses to comply with those arbitration awards. So that's when sort of arbitration as a landscape in India is very negatively affected. When people don't comply with or obey arbitration awards, there have to be consequences.
True. What is your take? How would India bridge the gap between myth and reality?
So India needs to be more proactive for arbitration to work. There have to be mechanisms in place where people who do not comply with or sort of just ignore arbitration awards,
right,
are dealt with in a professional manner, having consequences. Like, for example, I can say for example, we have a system in India which is called CIBIL, where someone defaults on a loan.
True.
They get reported to CIBIL, and
the score goes down.
The score goes down. So that same sort of system can be enforced for arbitration. You have 5 arbitration awards which you did not comply. Your score should be hit, and people should know that while they are dealing with you that you don't really follow your own arbitration awards, and if that is the case, they would stop dealing with you going forward.
True. That's a great idea which you shared.
So
in fact,
that's one of the ways in which arbitration can be made more effective and
right,
more reachable for the common man, because like what happens right now is arbitration is also expensive.
Right.
It's not cheap. So it has to be more accessible. When it becomes more accessible, it will become cheaper because more people will be into arbitration.
Right.
And when that happens, arbitration will become more successful.
True. It's a great idea which you shared with our audience. Thank you.
Thank you.
To come into the conclusion out here, what is your mantra for the emerging lawyers who want to pursue arbitration law?
Detail, detail, and detail. You have to be very detail oriented.
Right.
Gone are the days where you could just say anything and get away with it. You have to know your facts. You have to know your figures. You have to know everything that is in your brief. You have to be able to talk about your brief without looking at it. And that's when you would be a good lawyer.
Amazing.
Having the papers in front of you and talking about everything that you have is very easy. Anyone can do that.
True.
But if you're able to talk with a straight face without looking into your brief and you know everything that you have to say, that's called real preparation and detail-oriented preparation, where you should be able to narrate off whatever you have to say right from the top of your head.
Great. So the emerging lawyers need to understand that the preparation and detailed preparation
Exactly.
is what is required
Absolutely.
to be a successful arbitration lawyer.
Absolutely.
Thank you so much, Mr. Sayta, for your insightful knowledge on arbitration law.
My pleasure.
Thank you for joining
Thank you for
us
having
at
me.
the DNS podcast.
Thank you.